Hey, everybody, welcome to the Shanty. First of all, let me thank you all that came to the seminar last week. We had a great turnout. We really appreciate it. There was a bunch of you there. Really good program, lots of good questions, lots of good interaction, and we really appreciate it. So one of the things we talked about in the Shanty was the PUMP Act, which is Providing Urgent Maternal Protections for Nursing Mothers Act. And Kelsey Dame, who's here with me now, those of you that were there spoke about this act. And during the course of her conversation about what all this was about, she made a mention that we were supposed to get guidance on this. And lo and behold, on the 18th of May, the Wage Hour Division actually issued guidance. Kelsey at the seminar was a little skeptical on whether or not they were going to issue guidance. But in fact, they did issue guidance. So just a reminder, Kelsey, welcome to the Shanty. This is Kelsey's first time in the Shanty.
Yes.
And Kelsey's an associate in the Labor and Employment Practice Group, for those of you that don't know her. So Kelsey, just to remind everybody what the PUMP Act is, give us a brief summary of what this thing is and what it means.
Yeah, so the PUMP Act is an amendment with the FLSA, and the FLSA under the PUMP Act requires employers to provide nursing employees reasonable break time each time the employee has to pump breast milk at work for up to 1 year after the child's birth. The employer may not deny a covered employee the time that they need to pump. They also need to provide the employee with a private space that the employee can access whenever the employee does need to pump. So the frequency, duration, and timing will vary depending on the needs of the mother when she is returning to work.
Okay, so that raises a whole bunch of questions about what all this means.
Of
so
course.
Let's start with the word reasonable, because somehow I think that we might have a slightly different view of what reasonable is than the Wage Hour Division was. What is a reasonable amount of time?
Well, of course, the famous lawyer answer is it does depend. But the Wage and Hour Division provided a couple of examples of what reasonable means. One that I think is important to discuss is the example that's given. Irina, a shift manager at a fast food restaurant, takes 4 25-minute pump breaks each day when she returns to work after the birth of her child. Irina's need to pump changes as her baby grows, and when the baby's 6 months old, she reduces her breaks to 2 25-minute times. According to the Wage and Hour Division, that is reasonable. Another example that they give is Leslie, a department store delivery driver with a 9-month-old baby, needs 2 30-minute pump breaks each day that she works. So they give a couple of examples of what is considered reasonable. Of course, they don't give any examples of what is unreasonable. But I do remember talking to somebody at the HR seminar who said, hey, I have an employee that wants 3 1-hour breaks. I would hedge to bet that we could make an argument that that would be considered unreasonable, but as they don't provide any examples of what is or what is not unreasonable or what is unreasonable, then I think we just have to kind of go on a case-by-case basis.
Okay, so hopefully we have reasonable employees that take a reasonable amount of time. All right, so with that being said, does this mean that I have to pay employees when they're taking their breaks to do this?
So if your employee is completely relieved of duty during these break times, you do not need to pay the employee. However, if, for example, an employee is taking the time to express breast milk and gets a call from a coworker during that time and answers the call and needs to do something while she's pumping, that would be compensable time. But if the employee goes off to the private nursing room and is pumping and is not working, they do not need to be paid if they are a non-exempt employee.
Okay, and that was important. Non-exempt employee, right?
Yes, yes. Right. If they are an exempt employee, you can't deduct the time that the employee is expressing breast milk. You have to pay that time if they're doing work during the week for you.
So again, the answer is it depends whether the employee is exempt or not exempt and what they're doing. All right. Yeah. All right. So you just said good when they go off to the private space. So does this guidance give us any indication of what is a sufficient space to do this, okay?
Thankfully, it does. It gives us 4 guideposts as to what is going to be considered a sufficient space. 1, the space needs to be shielded from view from others. It needs to be 2, free from intrusion. 3, it needs to be available each and every time that it is needed by the employee. And 4th, it cannot be a bathroom. The guidance explicitly mentions that an employer has to consider the number of nursing employees that it has when designating these spaces so that they don't have to compete for the space. That would be a violation of the available each and every time that it is needed.
So in other words, you might need more, depending on how many people you have that need to do this, you may need more than one room.
That is correct. If you just have one designated room and you have 3 nursing employees and they all need it at 11 o'clock, you're going to find yourself in a situation where you're violating the Pump Act.
Is there any way to get out of this or around this?
You know, that's a fair question and one that I think that the employers are going to want to know. The only way that you can get out around this is 1, if you have under 50 employees, and the Wage and Hour Division has put in its guidance that this includes all employees regardless of work site. And 2, the employer will have to demonstrate that it has a significant difficulty in complying with the Pump Act. And of course, they're going to do so considering on a case-by-case basis. But the Wage and Hour Division's position is that because eligibility is only up to 1 year after the birth of the child, they think that they want a large demonstration of a difficulty in order to have an employer be exempt from these requirements.
Okay. All right. Fair enough. Anything else we need to know about this thing before we move on?
Well, like most legal requirements that we have out there, employees that are exercising their rights under these acts are protected from retaliation. So if you have an employee that is requesting time to express breast milk under the Pump Act, you can't retaliate against them or take any adverse action against them for doing so. I think that that's important to remember for this act and all of our other federal civil rights and state civil rights laws. Okay.
All right. Thank you very much. So those of you out there, if you have any questions about this, call Kelsey. Don't call me. Call Kelsey and she can answer your questions. Otherwise, we'll see you all next time.
Thank you.